Hi, welcome to your fifth set of notes in Unit 3 on the Constitution. These notes are going to be focusing on the amending process of the Constitution. This would be Article 5 of the Constitution. I've named these notes constitutional change because we do focus on more than just the amendment process overall, but amendment process is where we're going to start. So make sure you have your notes handout and turn it to the page that covers the amending of the Constitution. So here we go. All right, so I would like for you to just take a couple of seconds, maybe pause the video while you do this to kind of figure out, what do you know about today's topics? Like, what do you know about amending? What do you know about the amendments? Do you know about how like informal changes to the Constitution take place? Anything like that. Okay, so pause the video, kind of maybe jot down this kind of answer to this off to the side on your paper. Okay, so amending the Constitution, the amendment process is in Article 5 of the Constitution. That is the sole thing in Article 5. In our sentence, our mnemonic sentences to sentence to remember what each article of the Constitution is about, this would be the and of that sentence. So we had large elephants jump slowly and. So the amendment process is and, Fifth Amendment, or Article 5, sorry. This allows for orderly change. Now that is one thing under the Articles of Confederation that was not allowed, was the orderly change. So make sure you make a note of that, is that they have to address that because of the Articles. The Articles did not allow for orderly change. So put that off to the side. And then requires participation of both levels of government. So it's a great example of federalism, which we will be talking about later in this unit as well, and then provides opportunities for citizen participation. So the citizens can actually participate and be the true democracy. Okay, so here are your steps. So you want to definitely pause the video here and write these things down along with the other information that I give you in this on this slide that is not listed. So first off, there's a two-step process. There's the proposal process and then the ratification process. So a proposal, so the proposing of an amendment can happen in two ways, either by 2/3 of the members of both houses of Congress. So the members of Congress will have to vote for this. It means it gets introduced just like a bill would, and then it goes through the lawmaking process. It's not going to become a law, but it goes through a very similar process. It goes to the other chamber and it goes through, they may make changes. They have to, compromise potentially between two different forms. Where it differs from the lawmaking process is it doesn't go to the president. Okay. It will go to the states then. And then the second method is it at a convention called by 2/3 of the states. So if Congress is not listening to the people can ask their states to call for a convention. 2/3 of the states can call for what's known as a constitutional convention to consider an amendment. So this is one way in which the people are holding power. And so if Congress is ignoring the will of the people, then the people have a way to get around that. So make sure you have jotted down to the side of this that this gives the people power. Okay, this proves that the people are the ones that are in power. Now, we have a total of 27 amendments. Of those 27, 26 of them were proposed by option number 1. Make sure you write that off to the side, is that this was done for 26 amendments. I'm going to look for that. Okay, and only one amendment was proposed and passed and became an amendment on option 2. All right, now the second part of this process. So we have the national government role, which is the proposal, and then it goes to the states and the people, and that is the ratification. So now we're the local government control influence on this, and so it must be ratified. Ratified means approved, and there are two ways for an amendment to get ratified: either by 3/4 of the state legislature. Okay, so 3/4, which is like 38 states, have to agree to it. State legislatures take a vote and pass it, or by 3/4 of ratifying conventions in the states. Now, Congress will designate how they are wanting the ratification to go, because it can't be like a combination between state legislatures and ratifying conventions, but they will, they identify which method. Okay, of our 27 amendments that have actually been passed and approved and added to the Constitution, all 27 have been done by option number 1. So with option number 1, you need to write all 27 amendments. Okay, but the option 2 is given there in case state legislatures are not listening to their citizens. The citizens have a way around that. Okay, the founding fathers put in place ways to ensure that the people's will got heard and got done. Okay, also off to the side, you need to write that there have been 11,000 proposed amendments. 11,000. So off to the side, 11,000 proposed, but only 27 have been ratified. Way more than that were initially proposed, had been offered up for proposal. Okay, but 11,000 have actually gone to the states for consideration, and states have only met the requirement for 27 of them. Okay, so make sure you pause this, make sure you listen to the whole thing, and get all those extra bits that I told you to write down that are not on this screen. Now, let's move on. So that was the formal method, okay, and it can be hard to get done. There are some informal methods to how to change the Constitution. So informal changes are changes that occur informally as power is exercised by each branch. So each branch has a way, and some other outside interests have a way to kind of informally change the Constitution. It's kind of like writing in the margins of a document, right? Why would you write in the margins of a document? For me, when I write in the margins on, for a reading or a document of some sort, it's because I'm writing notes to myself. I'm getting clarification. I'm maybe putting a question out there on what does this mean, those sorts of things. So, I'm going to clarify, I'm going to summarize, I'm going to connect, respond. I'm going to do those things. I'm going to interact with that document, and that's what these informal changes are doing. So the first informal change is basic legislation. Now you need to understand that the basic legislation, means it's Congress, legislation, Congress, lawmaking. They might be passing legislation, laws, that are going to clarify parts of the Constitution, like clarify lower courts and adding courts, or taking courts away, or establishing or removing executive agencies. Okay, clarifying parts of the Constitution, but they can also clarify powers of Congress. So Congress has a power called the Commerce Clause. And what does this mean? Now, oftentimes what is involved here is they're also going to use the elastic clause. And I have this mentioned down here. The proper name for elastic clause is the necessary and proper clause. So write that out to the side. I'll be checking for that too, in there. So we're going to clarify what the Commerce Clause, what can they regulate? Well, a lot of what they can regulate can fall under the elastic clause, that necessary and proper clause that expands Congress's powers. Okay. Now, executive action. So this is what the president and the executive agencies can do to do informal changes to the Constitution. This has to do with war powers. So the president is commander-in-chief. Congress obviously can declare war, but there are war powers. What can the president do militarily, that doesn't necessarily require a declaration of war. Can he drop a bomb? Can he do reconnaissance missions? Those sorts of things, all within that. And that's going to be a interpretation of the powers given to the president. He can issue what are called executive agreements. They are similar to treaties, except the Senate is not involved in those. Congress doesn't have to ratify those. And then you have executive power. So what is executive power? It's the enforcement. And how do you go about enforcing it? So right now, the federal government, the president of the United States, and this started under Obama, is not enforcing the criminalization at the federal level of marijuana. That would be the executive power, enforcement power. Now let's talk about the judicial branch, the third branch. So the judicial branch and the courts, remember, they have judicial review. They have that power to declare things unconstitutional. And this traces back to a court case called Marbury versus Madison in 1803. And what happens over time is the courts can change their interpretation of the parts of the Constitution. How do we interpret the necessary and proper clause, or the war powers and those sorts of things? How do we interpret them? And they may interpret them differently and come to a different ruling. We saw that this past summer with the Dobbs decision concerning abortion, and essentially overturning Roe v. Wade, and turning the decision on abortion regulation back to the states. That was a change in the Constitution. Now, there's other participants that are involved in informal changes of the Constitution. Political parties are one of those. They are the ones who are going to be dealing with candidate nominations. Nowhere in the Constitution does it talk about how does a candidate get nominated to run for office. Political parties, and that is an informal change to the Constitution. Electoral college is a rubber stamp anymore, because it is supposed to represent the actual voters' vote in that state. Prior to 1900, the states could just pick how they voted. Like, it didn't matter what the citizens said. The states, the political party, but the states, especially the state legislature, could pick which side was going to win for their state. And then Congress is organized based on parties. So we have a hierarchy. We have a majority party, a minority party, based on parties, on our political parties. And then our last informal change method is custom and uses. So traditions. So the creation of a cabinet for the president, that was done beginning with Washington. So having that creation, that is custom. Okay, presidential succession. We changed presidential succession. It used to only go through the president pro tempore of the Senate, and they change it. They have a law that changes it and expands it. We have an amendment that clearly lays out how presidential succession, if something happens to the president and he needs to be replaced because he died, he needs to step down, he resigned, whatever it is, we have a plan in place. Something called senatorial courtesy. On senatorial courtesy, this is for judicial nominations, where the president would be vetting candidates for a judicial spot, and he would go, or she would go, the president would go to the senators from the state of the potential nominee, if they are the same party as the president, and ask their opinion, how they felt about the potential nominee. Because if the person is from the state of Oklahoma and the Oklahoma senators don't support that person, then it's going to be really hard to get them through the approval process in Congress. And then there's no third term rule. So initially in the Constitution, there was no limit to how many terms that a president could have. We've changed that. We have the 22nd Amendment, which was a change to the Constitution formally, but we just kind of followed precedent of George Washington. It wasn't until FDR that anyone ran for more than 2 terms. Everyone followed what George Washington did and just followed that. That was that custom, that usage. Okay, so these are the highlights or the very important parts of the informal process. All right, so this wraps up your 5th set of notes for Unit 3 on the Constitution. If you have any questions, come see me. And don't forget, don't do anything too stupid. Bye, guys.